The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
Welcome back to Condo Craze and HOAs here on our YouTube channel. I'm Karen Curtis. I've been with Eric Glazer for 15 years on this show.
Yes.
Yep.
Long time.
It's been a long time,
Yeah,
but
yeah.
it's
It might
really...
even be more. I got to check.
Oh, gosh.
Might be 16 at this point. We said 15 for a long time.
We have.
Yeah, right.
Well,
I got to check it.
Since he started, he's now board certified in community association law. He developed a class, a seminar that now HOA boards have to, it's been signed, it's mandatory.
Big week this
and
week.
The
We'll
condo,
talk about it.
oh my gosh.
Absolutely, yeah.
Yeah, so you're board certified, you have firms with attorneys in Fort Lauderdale and Orlando, and we're here each week to answer all your calls and emails that make life in your condominium or HOA absolutely crazy from 1 minute to the next, because we know you're just like losing it, and you can ask him whatever you want.
And that's why a lot of these new laws passed, and HOAs especially.
Yeah, to make them happy.
Yeah,
right, okay.
Exactly.
And you're going to get the phone lines going early, or you can ask a question in the chat box. Some people do both. The number is 717-GLAZER-8 with a Z. That's 717-452. 717-452-9378 is on your screen right now. And you can also visit Condo Craze and HOAs on YouTube, of course.
Hey, good morning, everybody. If you're a fan of the show, don't forget to subscribe to two things. Number one, the Condo Craze and HOAs channel on YouTube, like where you're watching now. We built up an amazing library. And Rob was telling me just now, hey, Rob, chime in here. The library is building up like nuts, and people are tuning in to do a search on all kinds of topics, I understand.
Yeah, it's growing, and you know, I think there's so many different topics which are solutions to a lot of people's problems,
Exactly,
right? So,
exactly. I'm very proud that you said that.
You're almost up to 100,000 views.
Yes, exactly. So proud to be doing it. And of course, the other thing you can subscribe to is our email list at condocrazeandhoas.com. We got, I think, 11 or 12,000 on that list as well.
Right.
And by doing so, you get announcements about the show, you get announcements about our seminars, announcements about the new laws, and four big ones were actually signed this week.
Really?
Yeah, the big HOA one was passed, and we'll talk about that. And again, condocrazeandhoas.com to sign up for it. And Monday, we do a new blog every single Monday at hoa-condoblog.com. Tomorrow's topic, some quick rules about making rules. Okay? Brand new. Hey, where else can they find us, Karen?
Oh, well, you can always find us on Facebook. And I don't know why we're on TikTok, but we are. Apple and Spotify.
Right, exactly.
Any platform that has a podcast, you're going to find the show.
Yeah, absolutely. And some
people will
big-
find highlights on TikTok.
Oh, the highlights.
highlights,
Okay.
yeah.
Okay.
Yeah.
As long as it's on your phone.
Right, exactly. All right, big news on the condo and HOA laws.
Yeah, so what happened this week?
Okay,
last week we discussed that the governor had the HOA bill on his desk.
All right, okay, so let's talk about that. The new condo bill, it's 1021. That hasn't even been delivered yet, okay? That's still sitting at the legislature. It hasn't been presented to the governor, but 1203, which is the new massive HOA bill that we've talked about here time and time again, it was signed by the governor this week.
So he has to sign these before July 1st, is when they go to effect?
The way I understand it, yeah, right.
Or if he doesn't sign it, it goes into effect.
That's the way I'm understanding it, but it's a little confusing as to whether or not it has to be presented to him first. But I know that the legislature, once they pass a law, it can't just not be presented from. He can't just say, no, I'm not going to ask for it because that it be delivered to me, because that in effect would be a veto. So I would think that, yes, he has a limited amount of time to have it presented to him.
I think you should
and
present
if
it
not,
to him.
I would love to present it to him. Well, as a matter of fact, Rob, you were gracious enough and worked hard enough to line up a pretty important interview this week with Representative Vicki Lopez.
Ah, she was part of the whole thing.
Yeah,
Good for you.
she really drafted the big HOA bill, really drafted the condo bill, and I'm going to be interviewing her this week, and we'll air that interview maybe next week or the week after.
Yeah, in the coming week, we'll hear from Lopez.
From Lopez. It should be a very interesting interview, and let me tell you, she worked hard, and I mean really hard, this legislative session, nonstop, to draft all these condo and HOA bills, and it's her work.
You've been silently, well, not silently, but you've been plodding year after year, trying to get the legislature to understand, because half the state lives in a condo or an HOA, right?
Yep.
And only one lawmaker was living in a condo, so they didn't really understand
Exactly.
condo
Senator
and
Pizzo.
HOA law.
That's right. And
Senator Pizzo.
Yep.
And so you've been writing letters and talking to lawmakers and saying something needs to be done for these people.
And look,
Finally.
on a lot of levels, certainly when it comes to making repairs and stuff, unfortunately, it took a tragedy. But Representative Lopez definitely grabbed the bull by the horns and said, okay, enough. We're hearing too many complaints about too many things. This is the one year we're going to sit down and address all of these complaints.
It had to be done.
And let me tell you, she did.
Good.
She did. You know, some people may like it, some people may not like it, but the bottom line is, she addressed it. Period. This is the year that all these complaints were addressed in one full swoop. So I think for the most part, many of these are great. I am in favor of many of these new laws that passed. We'll talk about them as time goes on. But today we need to talk about a really important condominium decision that came out of the Department of Business, excuse me, and Professional Regulations, and it has to do with condominium elections. And I will tell you, it's a very complicated topic that we're about to talk about. So like I say every once in a while, today is going to be like law school, everybody. You need to focus. I'm very serious when I say this.
It's like the jury in Trump's New York trial.
Yeah, let's just skip
So
that whole thing.
complicated.
Yeah, let's pass on that. But today, everybody needs to, I'm serious when I say focus for the next few minutes.
Okay.
We're about to talk about a very complicated topic. Certainly, if you're not used to dealing with things like this, of this nature, every day.
But they need to know
This is a
about it.
complicated topic. Certainly for condominium board members, you definitely need to know about this. So the next few minutes, put your thinking caps on. That's the bottom line, okay?
Okay.
It's not going to be easy.
Go ahead,
okay?
Professor, you have the
All
microphone.
right, so here we go. In 2011, I had the honor and privilege of arguing a case in front of the Florida Supreme Court called Cohn versus the Grand Condominium. So here's what Cohn versus the Grand Condominium was about. It was about obviously a condominium in Miami that many of you may know called the Grand Condominium.
Hey, it was just north of the old Miami Herald building
Yes,
off of
correct, on
the
Bayshore
Julia
Drive.
Tuttle. No, what's the other causeway there?
Arthur
Robert?
Godfrey? Was it
No, the little one, the Venetian.
Venetian Causeway?
Yeah.
Okay. Massive building, if those of you that know it. 1,200 units in the condominium.
Yeah.
Think about that in one structure. Out of the 1,200 units, 800 were residential, 400 was commercial.
Okay.
So obviously the residential unit owners outnumbered the commercial unit owners 2 to 1,
Right.
800 to 400.
There's restaurants and stores
Restaurants,
on the bottom. Yeah.
shops, hotel units, all kinds of things. Now, notwithstanding the fact that the residential unit owners outnumbered the commercial unit owners 2 to 1, all right, the bylaws of this community say it's the commercial unit owners that get to elect a majority of the board.
Whoa.
Sounded pretty unfair, right? So the Grand was built in 1986. 19 years later, the Florida legislature says, okay, Grand, and those of you who also lived in mixed-use condominiums, we hear your cries. So we're going to pass a new statute in Florida that says in these mixed-use condominiums, where you have the residents outnumbering the commercial unit owners, we don't care what the governing documents say. You can take those governing documents, throw it in the garbage. It's going to be from now on, it's the residential unit owners who get to elect a majority of the board, right? The people in the Grand are ecstatic, they're celebrating, right? Commercial unit owners say, wait, we're going to challenge this. And the case goes all the way up to the Supreme Court. What's their challenge?
Kaufman?
Yes, but before we get there, what is Kaufman? So they're saying basically that the contracts clause of the Florida Constitution, the United States Constitution, says you can't have a legal contract and they're saying we have a legal contract. The bylaws were a legal contract. The declaration was a legal contract. And the Constitution says you can't suddenly have a contract that's legal one minute and the legislature pass a law that makes it illegal the next.
Okay.
So the case goes all the way up to the Florida Supreme Court, and the Florida Supreme Court says we're going to rule in favor of the commercial unit owners. We're going to say it's illegal at the Grand. Why is it illegal at the Grand? Because at the Grand, there was no as amended from time to time language in the governing documents. What does that mean? We take a look at the governing documents that when they were recorded in 1986. Remember? Came into existence in 1986. The new laws were passed 19 years later.
So it doesn't matter if you don't have that language. Any new laws
That's what the
passed.
Supreme Court was saying. Exactly. So they
Doesn't
said,
apply to you.
Take a look, right? Unfortunately for the unit owners at the Grand, there was no and as amended from time to time language. The governing documents at the Grand say we only adopt the statute, Florida Statute 718, as it exists now in 1986 and not as it will be amended from time to time. Therefore, the new statute that requires that the residential unit owners get to elect a majority of the board, sorry, you ain't going to get it because you didn't have the Kaufman language in your governing documents.
That's like a technicality.
Yes, but a pretty important
Big one.
technicality, right? Pretty important.
Exactly.
Okay, so now that you know how it works, that you don't get the benefit of new laws if you don't have the as amended from time to time language, keep that in mind. Keep that theory in mind. So now we're going to fast forward to a brand new 2024 case. And the name of the case is Maureen Short versus Windover Condominium.
So wait a minute. I just want to put a
Yes.
point on this. You so therefore lost the case.
You had to point that out, right? But it was close, 7-0. Okay? Thanks, Karen. Appreciate that.
But they can vote Kaufman language in.
Correct. You can
So
amend your documents.
if you put it Kaufman language in, does that go grandfather back?
Yeah, you can bring the laws right into life that
Okay.
exist right now. I argued that at the time, my argument was, well, the government, the legislature, always has the right under their police powers to pass new laws for the health, welfare, and safety of the residents of the state.
Well, that makes
this
sense.
was a law that under the police powers the legislature thought was necessary.
Okay.
The Florida Supreme Court said you can't change a contract, period. Contracts are, sacrosanct, bottom line. Okay?
Yeah, well.
Okay, so again, let's go back. Now, brand new case, Maureen Short versus Windover Condominium. So let's now give you the facts of Windover. Windover is a 132-unit condominium. Keep this in mind, built in 1963.
Oh.
Okay? And in this case, the association argued that in order to have a valid election, all we got to do is take a look at Florida Statute 718-112, 2D4A, and that statute says all you need to have a valid election is 20% of the people have to vote in the election. And I can tell you when everybody does a condo election, attorneys show up to do condo elections, that's what we always say. Did 20% of the people vote? Did 20% of the people vote? Then we would have an election that counts, okay? The unit owner argued, wait a minute. There's no Kaufman language in this document. So that law that was passed in 1992, remember this condo was built in 1963.
Right.
So we need to look at the laws that were built that were on the books in 1963.
When did the Kaufman language become? How long
I don't
has that
remember
been?
what year the Kaufman case was passed, but I think in the 80s.
80s. Okay.
In the 80s.
So they were built before that.
They were
even
built way back in
existed.
1963.
Okay.
So the argument was, well, then the 20% rule doesn't apply. We need to take a look at what was the law in 1963. So what did the arbitrator rule? The arbitrator ruled that, yes, we do have to look at what the law was in 1963. The 1963 law says your election is determined by your bylaws, okay? Here, the bylaws of this condominium, again, which was built in 1963, say a quorum is needed in order to have your condominium election. How much is a quorum in that community?
More.
67.
Oh, my gosh.
So instead of 27, if you would have allowed that brand new law,
51.
the 1982 statute, it would have been 60. It would have been only 27. 27 was needed. Okay.
Which was 20%.
which is 20%. But the arbitrator said, nope, no Kaufman language. We're going to go back to what the law was in 1963.
Made it worse.
1963 said we look at the statute says we look at what your bylaws require. The bylaws here required a majority which was a quorum here. A quorum was 67. So it went from 27 to 67. Now, this is a major decision when it comes to elections, and condominium attorneys now have extra work on their hands when administering the annual meeting. It's imperative now to know, right, and I'm looking at my notes because there's so much to know. It's imperative to know when the condominium was built, right, and if the association has a as amended from time to time clause, right, in their governing documents. If there is the as amended from time to time language, the 20% rule applies. Period. You're good. It's easy, right? But if there is not, there's a lot you need to consider now. If there's not, a determination needs to be made if the condo deck was recorded before the 20% rule came into effect in 1992. If it was, you need to know what the statutory law was
at the time.
At the time, right. And regarding elections, and it probably defers, I should say, to the bylaws. And then you have to look at the bylaws. A determination needs to be made what's required under the bylaws. Good guess that it's probably going to be a quorum. So you're not going to be able to use that 20% rule either anymore.
And they probably
and
have
you're going to
been
need a quorum. Well, they probably have the 20%. Quorum you're not going to get. So,
you
big
need a
decision.
majority. You need, it's huge.
Yeah, big decision.
But they've been operating under the auspices of the 20%, but really should have had the majority.
Correct. Big decision here.
Oops.
Instead of just thinking, right, it's automatically 20%, not so fast. So, exactly right there, Karen. So before you run your next condo, you better get legal advice as to what statute applies in your governing documents, because it's a new ball game when it comes to your condo annual elections. It's a big deal. It's a big case. Okay? So now let's throw it, like we do every week, let's throw it to what our listeners think. Call in with what you think, and not only on this, but on any topic. 717-452-9378. That's 717-GLAZER8. Or drop us a question or a comment in the chat box on YouTube. I'm tired. I need to take a break after that.
You should be.
Right? We'll be back right after this.
There are very large management companies, and there are very small management companies. And I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
Oh no, an unexpected leak. Jay, you know that's no way to solve a roof problem. Call Best Roofing. We solve roof problems.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project. Visit us online at dmipavingandsealcoating.com.
Rimkus Consultants offer the professional expertise to help condominium and cooperative communities provide safe, compliant buildings for their tenants. We have more than 170 Florida licensed engineers and architects who are experienced with local regulations and can assist with Senate Bill 4D compliance. We can help with milestone structural inspections, capital expenditure evaluations, structural integrity reserve studies, and developer transition reports. Focusing on energy, resilience, maintainability, and sustainability, our experts can help with every phase of the building life cycle. For mitigation after a catastrophic event, building restoration, repair and remediation consulting, or Senate Bill 4D inspections, please visit rimkus.com.
Welcome back to Condo Craze and HOAs here on our YouTube channel. I'm Karen Curtis with attorney Eric Glazer, and we're done with our little spiel, so you can give us a call. The number to call and ask Eric a question, because he's board certified in community association law, 717-GLAZER-8, that's 717-452-9378.
Yes, understand the lines are stacked. How about we get our first caller?
Sure, let's go to Marie.
Hey, Marie, good morning. Where are you calling from?
Morning. Hi, good morning, Eric.
Where are you calling from, Marie? Where are you calling
Hello,
from, Marie?
Can you hear me? Oh, can you hear me?
Yes, can
Hello?
you hear me?
Okay, hi. Okay,
I'm not gonna get an
there
answer,
have
just
been a
not.
lot of fines and attorney fees paid out by our community for various reasons. I would like to know how to obtain all these records. I'd like to know what what we've paid out. How would I request these records? What would I say?
I think what you just said to me is not bad. So you can make a request, right, for any and all official records, right, that indicate what fines and or penalties or attorney's fees were paid by the association in any lawsuit or to the Department of Business and Professional Regulation. And that should
and how
sum it up.
How long does management have to reply to that request?
So they have
10 days, you said before?
10 days, 10 business days to provide you with access to those official records. Access. You know, a lot of unit owners make a mistake and they say something like, send me the following records. The association doesn't have to send you anything, okay? The only thing the association has to do is provide you access to the following records, as long as it's an official record of the association. These would clearly be official records. Official records basically are anything that has to do with the operation of the association, very broadly defined. So yes, you'd be entitled to these records unequivocally, but you can only ask for access to. Now, Marie, I'm going to ask for the fourth time. You going to answer my question?
Yes.
Where are you calling from?
I'm calling from Fort Lauderdale.
Thank you, Marie. Appreciate it. You have a great day.
Can I ask you, real quick, if I'm a board member, can I acquire addresses of all the residents? Am I allowed to get, residential addresses?
Under the statute, the board is required to keep a roster of all unit owners, and a roster includes their address. Okay? And by the way, that's something you can just get on the website of the county. That's easy stuff. You just go to bcpa.net, and then you'll find everybody's address anyway. Okay?
Okay.
Thank you, Marie.
For my community. Okay, thanks.
Have a great day. Who do we got, Rob? Who's next?
Let's see. Let's go to, what's the next there? They didn't put a name here.
Nameless.
But you might hear a beep, and so that means you're on the air.
Okay, you're on the air if you hear a beep.
Yes, hello. I think that's me.
You're
Helen
there.
from Miami.
See that? I didn't even have to ask her. Thank you, Beepless. How can I help you?
Yes, hi. Well, I originally called about a different topic, but considering your focus on today, I have two questions then, very quickly. The first is, we are having elections in the next couple of weeks, and the candidate bios for those who are running for the board just went out, and one of the bios is 3 pages long.
Yeah.
Now, my understanding is they should only be one.
That's correct.
So, first question is, what should happen in this case? And then number two, real quick, the question I actually wanted to ask is what requirements are there for a board to deliberate and to vote for particular vendors and on contracts before the membership? And our board is taking these votes behind closed doors, and we have no idea what's happened until after the fact.
Okay, so let's start with that question first. Contracts have to be voted upon in front of everybody. Okay, they can't be voted upon by email as well, right? What does the statute say? Boards can communicate by email all day long. They can't vote by email.
Okay.
So let's say, for example, you have a upcoming meeting this week for Wednesday, and you're going to vote on whether or not to hire Bob the landscaper. The board can communicate between now and Wednesday all day long. Do you like Bob? Yes. Do you like Bob? Yeah, Bob's great, right? We're all going to go with Bob.
Vote.
Everybody in favor of Bob? Say yes. Yes. Has Bob been hired?
No.
Bob has not been hired, because that vote has to take place Wednesday night at that board meeting, okay? So you have to have
so
that
if
vote in front of the community.
If Bob has been hired, though, does that nullify the vote and the contract?
No, it does not, because Bob will hold that the association to that contract every time.
And he's been
because
paid,
the
and
person
he's
that
done
signed
something.
that contract has, apparent authority to sign that contract. So I can tell you that that the association is bound to that contract.
But
period.
why would you not want to have it in front of everybody? Why would you
Don't
want to
know.
do it
The
behind
board
closed
should
doors?
vote on that contract in front of everybody, unless you know
Yeah.
that everybody's going to go nuts if you choose
Yeah.
this person, and they're not going to like the decision.
So what are the repercussions if they haven't done that?
The
and
repercussions
the contract
is
stays valid?
the repercussions is for somebody to say, put that on the ballot and vote on it in front of everybody. Someone could stand up at a board meeting and say, hey, how is it possible that Bob is doing the landscaping out there when you guys never voted to hire Bob? And see what an answer you get from that question. But that's about all you can do. Now, going back to your first question was regarding the election that you're having in the community, and somebody's bio went out with 3 pages. It should have been 1. Now, I will tell you, what does the statute say? That if you forgot to send out bios completely, you'd have to do a new election.
Oh.
The fact that somebody sent out a 3-page biography instead of a 1-page biography, where others specifically told that they can't have a 1-page, where they deny a 3-pager, where they specifically asked for 3 pages and denied the right? Do you know?
I know, but the instructions were 1 page.
Right.
Somehow this person didn't read.
I don't think that's going to be enough to require a new election. I think it would only be a situation where a new election is required if you didn't put the biography in at all. Next time, hold everybody to the 1-page rule.
We did a show on this, I think, and
Yeah.
we talked about you can do a 1-page with
Right.
English on one side and Spanish on the other side.
Right, I believe
Remember?
so, but that's it.
Right,
you know?
but both sides, though.
That was that the law at the time. You can do English on one side and
That
Spanish
was
on
what
one
I
side,
think
or
we
I
did
thought
a whole
everyone
show
was
on it.
limited to 1 page.
Oh.
But I think it's 1 page. Just bottom line. There's some
Not the back,
cases.
okay.
Yeah, just 1 page. Period.
Yep,
One
my condo
page.
is 1.
1 page. 1 page,
Okay.
8 by 10, and that's it. So yes, the condo should not have let this person send out a 3-pager. Unquestionably wrong.
But if it's just in Spanish, it's really what it's saying on the front page, so it's really 1 page.
I hear
It's just
you,
the same
but,
thing.
let's see if we can find a case on that. But
I think we did a show on
yeah,
it.
I thought it was just 1 page. But certainly 3 pages is not allowed. We agree on that, right?
Yes.
No way can 3 pages go out. But it went out. Is a new election required? I'm going to go with no. Okay? Thanks for the call. Much
All right, thank you.
appreciated. You got it. Who else we got, Rob?
Let's see, the next caller, it says Ira, I think.
Ira.
Yeah, let's see.
Ira. By the way,
Yeah, this is.
Wait, one second.
Can you hear me?
1 second. Just going to get back to that last caller. If you look at the statute, it says, substantial compliance is required. So if you make an error and you allow somebody to send out a 3-pager rather than a 1-pager, I would say, you still substantially complied in every other facet. You're good. You have an
Although
election.
it seems like an advantage if you can send a
No
3-page.
question, but it happened. Now, again, if somebody's biography did not go out,
Okay.
clearly a new election would be required. Okay, I'm sorry. Back to, who do we have?
Is it Ira?
Ma'am, you there?
Ira?
Yes. Who's calling?
My name is Myra. I got
Oh,
a beep,
Myra.
so I don't
Myra,
know.
how are
You're
you,
on,
Myra?
Myra.
How can we help, Myra?
Okay, so I'm in Brandon.
Yes.
Okay, so here's the situation. We have a new board. They've been on the board for 5 months.
Okay.
And we have 5 board members. I've been on the board for 10 years. I was president for several years. I didn't want to do it. So we have a new person now, new on the board, new president.
Gotcha.
And he is going through the money. He has gone through $30,000 in the last 5 months for
Sounds like a
frivolous
Democrat.
little
Go ahead.
things like landscaping and pool and everything that he thinks, beautifies the community, which is nice.
Right.
But the problem is, you talk about, the board doing this behind closed doors from the homeowners. What he is doing is behind closed doors without even board approval. Now, we have sent him numerous emails, all of us, the 4 of us.
Right.
You must have 3 people approve contracts, proposals. Every time you go to the attorney for every little question, you're running up huge attorney fees.
So let me stop you for a second.
The board,
Can
the
I
board.
hold on,
so
hold
my
on.
question is,
Oh, kill me.
because we've tried. I want the homeowners to be aware of what he's doing. I think they have the right to know. What is a good way for me to be able to communicate to the homeowners that what he's doing without sounding like I'm attacking
Okay,
him?
hold on. Is this the president that's doing this?
The president of the board is doing this. Yeah,
Okay.
he's new to the board. He has never been on the board, and now he's been doing this for 5 months, and the other board members,
I
they're
hear you.
also
He
new
didn't
to
take
me,
your
and we've all
Let's
told
turn
him
it-
you
okay,
can't
Rob,
do
let's
this,
turn
but
it
he
off.
continues to do it. He's spending money like...
I hope her husband has a lot of patience. Okay, so
The president
so-
didn't take your class.
Exactly,
He doesn't know what
yeah.
he's doing.
Okay, so here's the bottom line. And we've spoken about this so many times on the show, that sometimes someone will be appointed to the position of president, and they think they have the right to do everything and anything. Under Florida law, the president of the board really doesn't have any rights over and above what any other board member has.
And the board can take
Okay?
it away from him.
They're one of 5, and
Yeah.
that was the answer.
Yeah.
The answer is take the presidency away from him. The board members get to decide who the officers are going to be.
Right.
They decide who's going to be the president, vice president, secretary, treasurer. And she says they're complaining about it for months and months and months.
You have the power.
But they're not doing anything. They don't realize they have the power to take it away in a second. Just schedule a board meeting, right? And it's a new organizational meeting. They're going to call it organizational meeting, and shake it up.
And tell him to take Eric's class
Yes.
so he knows what he's doing. Maybe he can be
Remove
president
the
again.
person from, and actually all of them should take the
Yes.
class. Because they don't realize that the president is just like them. Now, what does the bylaws typically say? The president is the one to sign the contract. It does not mean the president gets to choose who the vendor is going to be. It means that if there's a contract that the board wants to enter into, the president's normally the one that signs the contract. That's all, but he doesn't get to choose who the vendor is going to be unilaterally. So, shake it up like Karen says. Call a board meeting. At that board meeting, say, sorry, we didn't listen. You're now just a director. You're not the president. You're not the vice president. You're not the secretary.
You're
You're not the
impeaching him.
treasurer. You're just a director. That's the way to do it going forward. Let's take our bottom of the hour break. Taking your calls, everybody. 717-GLAZER-8. Again, 717-GLAZER-8. 717-452-9378. Or drop us a question or comment in the chat box on YouTube. We'll be back right after this.
Is your condominium or HOA in need of accounting services? Look no further. Gerstel, Rosen & Goldenberg is one of South Florida's largest accounting and auditing firms, as recognized by the South Florida Business Journal, and is one of the few accounting firms uniquely specialized to provide accounting services to their growing condominium and homeowner association clientele throughout Florida. With primary offices in Aventura and Boca Raton, satellite offices in Naples and Orlando, and a professional staff of 65, Gerstel, Rosen & Goldenberg is prepared to meet the needs of any condominium or HOA in the state. The professionals at Gerstel, Rosen & Goldenberg also have experience working with timeshares, cooperatives, hotel condominiums, mixed-use buildings, and ancillary operations like restaurants, spas, and country clubs. Put their 25 years experience in your corner. Gerstel, Rosen & Goldenberg, 305-937-0116. That's 305-937-0116 or grgcpa.com. condominium.
Someday, you will need insurance. And for that day, you'll be glad you wrote down Insurco Insurance and Financial Services. Why? Because Insurco virtually insures everything. They're a full-line insurance agency that'll put together the best possible coverage and premium for almost anything. Need homeowners or condo insurance? Call Insurco. Need auto or motorcycle insurance? Call Insurco. How about golf cart insurance or trailer and RV insurance? Just call Insurco for a free quote. They're open every day. From renter's insurance, officers and directors insurance, and personal liability umbrellas to all types of business insurance, boat insurance, cancer policies, life, health, and annuities. All you need is Insurco. Get a free quote. They service Dade, Broward, and Palm Beach. Speak English and Spanish. Insurco Insurance and Financial Services. It's the only name you need. Office at 14401 West Sunrise Boulevard in Sunrise, inside Edmore Chevrolet.
Call 954-846-1206. 954-846-1206. That's 954-846-1206.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new by means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion, or call us directly at 561-853-5463.
Welcome back to the second half hour of Condo Craze and HOAs here on our YouTube channel. Lots of questions. We have like a record number of people watching. Thank you for joining us. Also, someone asked about putting the new laws up on your website.
Yeah, Rob's going to create a landing page the way I understand it. Rob, you're going to be able to get that for our listeners, right?
Yep, we're going to create a landing page so that you can see all the updates.
That's fantastic. Yeah, I already have it broken down. Here's a set of the new condo laws. Here's a set of the new HOA laws. So
that's already up there.
Is that I have it for myself.
Oh, okay.
And matter of fact, what I tell people is if you want a copy, email to you.
Okay.
Just write me, eric@condo-laws.com, eric@condo-laws.com. I'd be glad to send you a copy.
And the website is?
For the show or for the law firm?
Where's
for the
it?
show, it's condocrazeandhoas.com.
Is that where you're putting it?
No, email it to me. You just email it to me and I'll send it right back to you. It's not posted on the websites yet. Rob is going to create a whole separate link for it, right?
Yes.
On which website, though?
We'll put it on Condo Craze
Beautiful.
and HOAs.com.
Okay, great. Look forward to that going up there. Hey, I want to give a shout out to someone that we all know and love and miss very much. Hey, VJ Styles. VJ Styles. VJ, how are you? VJ was the former producer of the show when we were on the radio.
That's right.
So VJ, love and miss you, buddy.
We do, buddy.
Thanks for listening. One confusion by Vidal writes in and he says, DeSantis signed all the bills this week. Not quite yet. Okay, still hasn't signed the major condo bill. So
believe me,
hang out.
You would know
exactly
when that is signed.
I would know. Vidal thinks I missed it.
No.
Yeah, I didn't miss it.
Believe me, because we're going to have a party.
And we will have a party.
Yeah.
Right, that's a big deal.
That's a big deal.
Back to the phones. Who do we got?
Let's go to Joanne.
Joanne, how are you?
Hi, Joan Johnson. I am in Tampa.
Great, thanks for calling. How can we help?
Well, I'm in an HOA, 79 homes, and because they didn't go to your classes, the board fell victim to the MRTA thing and had to revitalize.
Oh,
MRTA.
So is our... What's that?
Okay, go ahead. Sorry. I had fainted there for a minute.
So...
yeah, when everybody
So
realizes what happened, they'll faint too. They understand. They'll understand. Okay, so what happened?
Well, in 1986 is when this HOA started. So then when they lost the documents and had to revitalize is our new birth date 2016 for referring, since we don't have Kaufman language, for referring to the laws that apply to us.
So that's interesting. What you're doing is you're bringing back, and let's think this through. So the question was, and first of all, we have to talk about what MRTA is. When the association came back to life in 2016, right? So the documents expired. This was created in
Before
1986.
The 86, yeah.
After 30 years, there was no more association because of MRTA. They were revitalized.
And it's an HOA.
In an HOA. Yeah. So which law applies, 86 or 2016?
Oh.
And the answer to your question is it has to be 1986. Why is it 86? Because you are revitalizing the old document, okay? So it's got to be the 86 law. Now, more importantly, you hit on something that we have to teach all of our listeners that are in our homeowners association out there. Really quick, if you live in a condo association, you're governed by your declaration of condominium. And that's a big document that courts generally refer to as your condominium's constitution. Now, if you live in a condo, that never expires. 100 years from now, when your unit's still there and being sold and transferred, it's going to refer to your declaration of condominium, okay? An HOA, different ballgame.
And if it expires, you're no longer in an association. You can paint your door purple.
Correct. Now let's explain to our listeners, in an HOA it works different. HOA, and I'm oversimplifying it here, 30 years after that declaration goes into existence, it can expire if not properly preserved. And what happens if it's not properly preserved? You just hit it. All of a sudden you're living in a community where there's no declaration.
And you don't have to pay any dues, nothing.
Correct.
You can mow your own lawn.
There's a case out there that says, as a matter of fact, on that issue, where an attorney knew that the declaration had expired, okay, and still went after people for not paying their dues. That attorney was then sued.
Of course.
And the court said, yep, we're not going to dismiss the case because the attorney knew that once that declaration expired, it was no longer in existence any longer, there was no reason to sue people for unpaid dues. They had a right not to pay. So, again, bottom line is...
So the people knew as well that it had expired.
Yep. So the bottom line is, if you don't properly preserve, and it's so easy to do.
Why wouldn't he tell the board they need to...
Don't know why, but very easy to do. If you know you're approaching the 30-year mark, make sure that you properly preserve your declaration.
What do they have to do that?
Very simple to do. There's a form that you fill out, basically. You follow the guidelines of the form, you record it for $10, you're preserved for another 30 years.
Okay, and so if you don't do that, what do you have to do when MRTA? What do you have to do?
Know if you blew the deadline, it's a disaster. It's a disaster. Because now you no longer are preserving the documents. You got to revitalize the documents, and it's no longer by just filling out a form. Now you got to get a majority of the people that live in your community to agree to bring the documents back. They may not want to. A lot of people like living in a community that they don't have to pay.
That's right.
And I will tell you that Jan from CCFJ takes the position that, yes, a lot of people definitely don't want to bring back the governing documents. They're very happy to live in a community with no rules and regulations anymore. So if you live in an HOA or if you're on an HOA board, you want to make sure to check. As a matter of fact, there's now a statute that requires HOA board members. The first thing they have to talk about after in their board meeting, right after the annual meeting, is, hey, what's the status of our governing documents?
Really?
Mandatory that they talk about it. Right on point so that you don't blow the deadline. Okay, very, very important. If there's ever a topic that people in an HOA need to learn, it's the MRTA rule. Preserve your governing documents within 30 years. If anybody's listening out there and they're not from an HOA and you're not sure what the status is of your governing documents, hey, were they preserved? Stop, take a look today.
Check
You do have a homework assignment. Take a look. What is the status of your governing documents? If you're in your 25th year, right, just do it now.
Do it now,
right.
Okay.
Properly preserve them now. You're good for another 30 years.
Okay.
Don't leave it for another board to do, 4 or 5 years from now, because if they blow the deadline, you're in a community with no rules, regulations, no declaration. Let's do this. Let's take our final break of the hour. Keep the calls coming in, 717-452-9378 or 717-GLAZER-8, or drop us a question or comment on YouTube. We'll be back right after this.
Is your home or condo looking old, worn out, and in need of a fresh look? Then you need PD Painting to paint your property and make it look like new again. PD Painting will first properly prepare your home and condo, and then use only the highest quality paint products. After many years in the painting industry, PD Painting has achieved a reputation for always delivering a reliable and professional finish. PD Painting is fully licensed and insured and offers a 7 to 10-year warranty. Their technicians are expert craftsmen. Let PD Painting handle all the details, and then sit back and watch them restore your property and bring back that brand new look and feel. Need a service call? PD Painting will be there on the spot. Need financing? PD Painting can offer that too. Call PD Painting at 888-416-3204. Again, that's 888-416-3204. Go to the website pdpaintinginc.com. Need painting done in your home and community? Contact the experts at PD Painting.
This message is for anyone who has taken on the important responsibility of becoming an officer or director in a homeowner or condominium association. It is also for the management companies who work closely with these caring people to make sure things are done the right way. Hello, I'm Gil Pomar, South Florida Regional President for Center State Bank, now the second largest bank based in Florida. Our bank, Center State Bank, has an amazing team of professionals who are exclusively dedicated to the homeowner and condo association market. Your job is not easy. There are repairs and new projects that need financing. There are legal and social issues that need to be understood. There are also technology and servicing issues that your residents want to be improved. Why not choose a bank that knows this business backward and forward? Why not have a local banker who will meet with you face to face whenever it is convenient for you or your board? Center State Bank has over 2,000 associations as customers for a reason. Please give us a chance to earn your business. Call Terry Russo at 954-633-1666 to make it happen. Center State Bank is an equal housing lender and a member of the FDIC.
Need an insurance evaluation, audit, or quotation for your condo association or homeowners association? If so, then you need to speak with our insurance experts at Mack & Waltz. We insure over 800 associations, and we are the clear leader in this marketplace. Mack & Waltz has been in business since 1989. We write insurance on billions of dollars of property values. We are an independent insurance agency representing insurance companies which specialize in condo and HOA insurance. The staff at Mack & Waltz works closely with board members and property managers and regularly attends association meetings to help educate the association about their insurance policies. To learn more about how Mack & Waltz can save you money and improve your insurance program, call now 954-640-6225 and ask for Greg Waltz. 954-640-6225. Mack & Waltz Insurance Group. Let us protect your association. So welcome to the final segment of Condo Craze and HOAs here on our YouTube channel. Eric Glazer, board certified in Community Association Law. And if you want to still give us a call, the number is 717-452-9378. And that comes out to 717-Glazer8 with a Z.
So many great questions and comments on the YouTube channel, and the calls today have been great. Let's take one from the board again. Louis Getz writes saying, what if the board members hire Bob via email and then ratifies the action at the next meeting? Great question. If they vote to hire him at email, technically, no, that's not something that they should be doing. But if they take that vote and they ratify it at the next meeting, I got no problem. As long as they take that vote to hire him at the next board meeting, I got no problem doing that. Who else? Ann Fargy, Miami Realtors. Snapper Village Specialist writes in, good morning, Eric and Karen. Thank you for enlightening us in your dedication to public education. As a former board member and real estate professional with 20 plus years experience, I truly appreciate it. I think Karen and I will both say it's an honor to be with everybody every Sunday, and I seriously mean that. Like I say, never feel like I'm waking up to go to work on a Sunday.
I love it.
It's truly found something that I love to do. James Lippo writes in, does the 8-year rule passed in 2018 that limits board members to holding office for no more than 8 consecutive terms apply, or is it subject to the wording of the governing documents? That is a great question. Okay, so for those of you that don't know, there's a law that passed, it's on the books right now, in a condo, can't serve for more than 8 consecutive years. That first date that you count, however, is the year 2018. So this law will not mean anything until 2026.
Oh.
Okay? Now, the question is, suppose you don't have Kaufman language, okay? Should this law apply? Well, here we have a law that takes away a substantive right of mine. It prevents me from serving and running for the board of directors, right? So I certainly have an argument that says, wait a minute, time out. You can't take away my right to run and serve on the board of directors unless there is Kaufman language in my governing documents which adopts that statute. And I would have to agree with that argument. Okay, I'd have to agree with that. So without Kaufman, there's going to be a lot of laws that, you know, if you documents don't have the Kaufman language. Someone had raised the question before about fining.
Yeah.
Well, if your documents don't have fining, your documents do not allow for fining, and your documents predate the law that allowed for fining regardless of what your documents say, and I think that law came into effect like 2010. So again, so let's say your documents do not have Kaufman language, do not allow for fining. You don't get the benefit of fining people because of that law that came into effect in 2010 if your documents don't have Kaufman language. Now, a lot of associations out there are fining anyway. Let me tell you something, you get a smart unit owner out there that's been fined, they use it as a defense, they win, believe me, attorney's fees assessed against the association. Embarrassing, okay? So if you think about what I just said, go check, and they don't have to pay the fine, but you will have to pay their fees and costs. Back to the phones, who do we got, Rob?
Let's go to someone named Eric.
Eric, I know there's something I like about them. How are you, Eric?
I like you too, Eric, and thank you so much.
You got it. How can we help?
Okay, this is kind of a tricky one, but the president of our association was charged with assaulting an owner of our condominium association, and he was arrested by the police, handcuffed, and charged.
Okay.
And then it appears that he turned around. I don't know if he hired the association's attorney or another attorney, but that initial cost was $3,700.
Okay.
And he used the association's money to pay for his defense.
Okay. Clearly, that's not.
That legal?
Yeah. No, I think there's a conflict of interest there. Clear conflict of interest. Here we have a guy that's being charged, right, with harassing the unit owners, right? Harassing unit owners. Yeah. That's something that by the that the association should take a separate, independent look at, and there may be that may have happened. Right?
But that's not as his capacity.
Certainly not in his capacity, right? Or maybe he was doing it in his capacity as a director, as an officer, but all the more reason why that should not be paid for by association funds, right? Clearly there's a conflict there. And I will tell you that if the brand new condominium law passes, and it might even also be in the already passed HOA law, the effective July 1st, you cannot use association funds specifically for something like that. So the statute even clarifies this effective July 1st. You cannot use association funds, by the way, if you're a director out there, if you get arrested, if you want to sue a unit owner for slander, in addition, can't use the association's funds for retaliatory conduct. That's clearly in the new statute now. And again, even without the statute, I think we have a situation here where, no, absolutely, that is director should not be using association funds for the defense here, because if he did it, that's clearly going outside the realm of something that you're allowed to do as an officer or a director, clearly should not be entitled to reimbursement by the association. Clearly a conflict there. Okay? So I hope that answers your question.
Yeah,
Who else? Yep.
Well, the board supports him 100%.
Yeah.
They stand behind him.
Well, it doesn't mean the board is right. When someone is arrested for conduct like that, no, it clearly requires that someone go out and get their
criminal.
Yeah, it's a criminal charge. They should be defending themselves on a criminal charge. Clearly. Okay.
Can I call up our attorney and ask him, because it's all lumped into our legal expenses. Is there any way I can call the attorney and see specifically if he represented them and billed us for this money?
You can do that. Doesn't mean the attorney is going to answer you. You're more likely to get a response if you ask the association under Florida Statute 718, you can ask for, tell them you're doing a unit owner inquiry. A unit owner inquiry. And by law, they have an obligation to answer you within 30 days. If they refer it to their attorney, they get an extra 30 days. So if you ask that question under 718, you call it a unit owner inquiry, they must answer the question. Okay, Rob, got to go to the next caller.
Thank you.
Thank you.
Who's next? Who do we got?
Next caller, I think it's Moshe.
Moshe. How are you, Moshe?
Hi, Eric. Let me ask you, we're going to have a special assessment for a recertification. It'll be about $5 million.
Okay.
So one of the questions I had from our treasurer was, could we offer an option with an incentive to pay it up early and giving a 5% discount?
Absolutely.
Is that legal?
Well, no, I don't know if you can offer a discount, because then you would allow people to pay separate amounts. So I'm going to go with no. I don't think you can ask people to pay it early and in exchange they get a discount. No, I'm going to tell you what you can do, and there's a declaratory statement right on point by the DBPR. You can say if you're going to pay it over time, you're going to pay it with interest. But if you're not, if you want to pay it in a lump sum up front, no interest. That you can certainly do. And again, there's a Department of Business and Professional Regulation declaratory statement right on point. But I don't think you can say you get to pay less if you pay it to the association if you pay it up front. Okay, do you understand the difference? You can save the person the interest, but you can't let them pay less. Right, you can't give them a break, because there's another statute that says everybody got to pay the same thing. Okay, so Moshe, I understand the incentive there, but no, I don't think you can give the unit owner the permission to do that. Can't give them that shot. Okay, but good call.
Okay,
yes.
thank you.
Excellent
Thank you,
question on the chat
Yeah.
that follows up with Murda.
Yes.
So their documents, they failed to preserve them.
Yes, okay.
And for 5 years before it was revitalized, people made changes in the HOA.
Oh,
now the board wants to come back and find the people that made the changes during the 5 years where the documents didn't exist.
They made changes to a document that doesn't exist.
No, they made changes to their homes.
Oh, they made changes?
Right.
No, good luck with that. No,
Yeah.
when those documents were out, they had the right, just like they had a right not to pay assessments.
Right.
Same thing.
Okay,
They had
so
a
they
right
can't
to
go
make
back
changes,
and
no
say, now
chance.
that we've revitalized you.
We're going to go
and
after you?
go.
Good luck with that.
Okay.
No chances. I mean, there's a case on point that says you don't even have to pay.
Right.
Clearly, those documents don't apply to you any longer, and that's the risk you run.
And now that it's revitalized, the clock starts again.
Correct.
And you go back to the original documents, but those 5 years that it wasn't. Okay.
Guess what? You don't get a chance to go after them. Exactly.
Okay.
That's exactly right.
Thank you, Anthony Rossetti.
Time for maybe one more.
All right, let's go to it. It might be Cheryl, it might be Jerry. If you hear a beep, you're on the air.
Yes, hi, how are you? Can you hear me?
Yes, where you calling from?
And what's your name?
I'm calling from Delray Beach.
Oh.
My name is Jerry.
Hi, Jerry.
Condo, and I'm calling and I have a question. Our budget committee finally noticed that they were having a committee, and when they went to it, they started to discuss contracts.
Okay.
And after the meeting, notes were prepared, and the committee then was notified by the treasurer that you can't discuss contracts by preparing a budget for the board to consider.
I don't know what that means, but I'm confused by the question.
They are not to discuss the contacts of any contracts and what we're paying for a contract and how much it is and so forth.
Any unit owner is entitled to not just to know about the contracts, they're allowed to get a copy of any contract. Any contract that the association has with any vendor whatsoever, including the attorney, including the accountant, including the lawn guy, including security, whoever it may be, any unit owner is entitled to a copy of the contract. All they got to do is ask for it, right? Written in a crazy difference between condos and HOAs. The condo statute says you have to ask for it in writing. The HOA statute says you have to ask for it in writing, by mail, certified mail, return receipt requested. Okay, big difference between the two. I don't know why, but That's the way it is. If you ask for it that way, again, they got to give you access to the records. They don't have to send you anything, but you're entitled to any contract that the association has entered into, period. As a matter of fact, the law says you have to hold contracts for the last 7 years. So you're entitled to any previous contract that the association entered into.
Wow.
Yeah. When it comes to records, bottom line is, clear position that the law takes that
Your
unit
management
owners
company should
are
know that.
entitled to copies of records. Bottom line, very, very clear line of case law. Statute's very clear. 7 years, you're entitled to all of it. Okay, except for those very limited amount of records that you're not entitled to see. Okay, like attorney-client privilege records for the obvious reasons. And on that note, you guys exhausted me today.
Are
to
you
be
okay?
honest. Yes, yes. But it was a great show. I had
It was a great
a
show.
lot of fun today.
Oh, by the way,
A lot
I
of
just want to
great
say,
questions.
Deborah says, I hope our association is listening. Brandon, Florida, no Kaufman language, exclamation point.
Here you go. What can I will tell you, sometimes they may think it's a good thing we didn't have Kaufman language because we wouldn't want this new law to apply. to us.
Right.
But boards will, I can also tell you that if you don't have Kaufman language, a lot of the remedies that you think you have
Right,
against
you
non-paying
don't.
owners, you don't have any of those remedies, like preventing them from using the common areas, fining them. You can stop them from running for office if they're delinquent. You can't use any of those things without Kaufman language.
And how
That I
can you
tell
get Kaufman language in your documents?
You can amend. When this came down, we found about 40% of
Amended.
the associations out there basically didn't have it. So you could amend your documents, which would require a 2/3 vote, a 3/4 vote. Stick it in there now. It brings you up to the 2024 statute as it is now, and you'd automatically get all the amendments going forward.
Going forward, but
Going
not in the past.
No, you would be brought up immediately
Oh,
to the
okay.
2024 statute.
Got it.
Okay, and then going forward, nothing else you have to think about
Okay,
going
cool.
forward. Okay, all right. Brings us to the end of the show. Yeah, Rob, go ahead.
If someone has a need for education and training, who do they call?
Who do they call? If you need legal help off the air, you can call Glazer and Sachs 954-983-1112. 954-983-1112 during the week. And like I said, we got the interview of Vicki Lopez,
Yeah.
Representative Vicki Lopez this week. We'll put it up there maybe next week. We'll see how that goes. And regardless, we will see you and speak to you again next Sunday at 11 a.m. on Condo Craze and HOAs. Guys, thank you so much for tuning in each and every week. Have a wonderful, safe week. See you next Sunday.
Thanks, Eric.